Today on Legalese, we will be discussing the case of Sheetz versus County of El Dorado, in which the Supreme Court would rule unanimously that extortion is in fact unconstitutional. Hey, greetings everybody, and welcome back once again to Legalese. Now, as always, I am your host, Bob, and I want to thank you all so much for joining me here today. Now, if you happen to be new to my channel, let me especially welcome you. This is a podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, I just want to remind you guys real quick, if you want to find out more about our show, you can go check out our homepage over at legalespodcast.com. And if you want to stay up to date whenever I put out new content, because I don't just do these videos on YouTube, I do articles on Substack, I release to alternative platforms, I have an audio-only version of the show, and whether you wanted to get notifications for all of those things or just some of those things, either way, all you have to do is go sign up for our newsletter over at legaleseshow.com, and you will get notifications sent right to you. All right, we have got a lot to get to today, so why don't we just jump the fuck right in? So as I mentioned right off the top, we are going to be talking today about the case of Sheetz versus County of El Dorado. Now, this is one of the few cases that I unfortunately wasn't able to cover as part of my Supreme Court roundup, just as a purely practical matter, really. There are really only so many cases that I can try and make the time to cover so deeply from start to finish the way I like to with my roundup, but this is a case in which a citizen fought back against a corrupt county government's policy of extortion, which comes into direct conflict with the takings clause of the Fifth Amendment, which is precisely the kinds of case that I love to cover here on this show, as anyone who watches knows. And here the government was trying to avoid takings clause liability by claiming that there was some sort of legislative exception to the takings clause. So today I want to talk about this case really for two primary reasons. The first being it is a fascinating case. The second being that this case was a big win for property rights and the Fifth Amendment, and that is always worth recognizing and celebrating. And in fact, this case is very similar to other cases that we have been covering here on this show, including a case from last term that we talked about quite extensively. That was Tyler v. Hennepin County, when the Supreme Court would unanimously rule that the practice of home equity theft was unconstitutional. And in Tyler, the court would hold that Tyler plausibly alleged that Hennepin County's retention of the excess value of her home above her tax debt violated the takings clause, and that Tyler's claim that the county illegally appropriated the $25,000 surplus constitutes a classic pocketbook injury sufficient to give her standing according to the TransUnion precedent. Now, Sheetz also bears a striking similarity to another case that we have been extensively covering this term. And besides the similarity in law and fact, I have already predicted the outcome of the case will be functionally identical to the court's opinion in Tyler and Sheetz. And this is the case of DeVillier v. Texas, which actually just came down today, actually, so we'll be talking about this more in the future. But in DeVillier, the question before the court had been whether a person whose property is taken without compensation may seek redress under the self-executing taking clause of the Fifth Amendment, even if the legislature has not affirmatively provided them with a cause of action. Now, the court did rule unanimously in DeVillier that this claim could proceed under Texas's state law's cause of action, and I will, of course, be doing a video doing an in-depth analysis of the court's fantastic decision in DeVillier. But as this ruling came out between my recording of this video for the Sheetz case and my ability to cover it in its own right, I couldn't simply just ignore the strong similarity and equally applaud the decision here in DeVillier. So in this case, Justice Thomas wrote for a unanimous opinion for the court, and just to provide sort of a brief summary of how the constitutional rights can be litigated here in federal court, what Justice Thomas held was the constitutional rights do not typically come with a built-in cause of action to allow for private enforcement in courts, and he cites Egbert v. Boole. He says instead, constitutional rights are generally invoked defensively in cases arising under other sources of law or asserted offensively pursuant to an independent cause of action designed for that purpose, e.g., 42 U.S.C. Section 1983. And here, Justice Thomas would describe the sword-shield dichotomy. When a constitutional right is asserted offensively, it must be brought pursuant to an independent cause of action designed for that purpose, such as Section 1983. Now, by contrast, a constitutional right can be invoked defensively without a cause of action in a criminal prosecution or some other state enforcement action, and this simple dichotomy reconciles Griffin's case and the case of Jefferson Davis, and it also makes sense of much of the court's remedies doctrine. Now, as I noted earlier, Justice Thomas would cite Egbert v. Boole, but this case is really only concerned with a limitation on the Bivens remedy. That case did not speak to the offense-defense or sword-shield dichotomy, and Thomas only cited Section 1983 itself, which does not directly support the proposition at issue, but still, we think the court has clarified the law here in a very important fashion. And really, frankly, as best as I can recall, the decision in de Villiers may be the cleanest statement of this principle in all of the court's precedents. So you guys will definitely want to check out my video talking more about that case. But getting to the matter at hand here. Now, in Sheetz, the question presented is whether a permit exaction is exempt from the unconstitutional conditions doctrine as applied by the Nolan and Dolan exceptions, simply because it is authorized by legislation. But before we blow our load on the majority opinion, why don't we step back for a minute and get a picture of the facts of this case? So, George Sheetz would build his career and livelihood as an engineering contractor and consultant in Northern California. Now, in 2016, he began preparing for retirement and bought a vacant lot in rural Dorado County for a small manufactured home where he and his wife would live and raise their grandson. Now, he got his home, but it came with permit fees so exorbitant that he made a federal case out of it, and I'm very glad he did. And this is a case that would go, as you know, all the way to the Supreme Court of the United States. Now, I suppose it goes without saying that George Sheetz knows the ropes and red tape involved in new construction, and he figured the process would be even easier for a manufactured home such as his because it's already built and had passed the necessary government inspections. But once his land was ready, and all George needed was a county building permit, he was stunned, when he was told that to have this permit, it would involve paying a so-called traffic impact fee of more than $23,000. Now, the county claimed that it was bound by law to charge this fee for roadwork his project might cause, although it provided absolutely no evidence tying any future roadwork to any public cost or impact imposed by George's project. Now, the government's fee was nothing more than an exorbitant ransom to pay for permission to build a small manufactured home. It unfairly imposed costs that had nothing to do with his project, and George Sheetz weighed the immense cost against the hard work he had put into his land and his yearning for a retirement home, and so he paid the fee under protest. Of course, the county would ignore his protest, so George would sue, arguing the fees constituted an unconstitutional permit condition under 3 separate Supreme Court decisions. Now, in the Supreme Court's 1987 decision in Nolan v. California Coastal Commission, they struck down certain government demands for land in exchange for a permit as an out-and-out plan of extortion. Now, this ruling determined that all permit conditions imposed on land development must relate to actual harm caused by the development, and the government would expand Nolan's scope in 1994 in the ruling of Dolan v. City of Tigard, and that government demands must be sufficiently proportional to the actual impacts of the proposed use. And then in 2013, the court would extend the precedent set in both Nolan and Dolan to permit fees in another case, which is Kuntz v. St. Johns River Water Management District. And that is that the government cannot weaponize the permitting process or extort more land or money from property owners than is appropriate. Now, despite the conclusive precedent that the Takings Clause trifecta, curbing unconstitutional permitting conditions, some lower courts would find a legal loophole for state and local governments rather than focusing on the legal doctrine established in Nolan and Dolan and Kuntz. Some courts would focus on the fact that the permit conditions at issue in these cases were ultimately imposed by bureaucrats as part of a permit review process. Those courts would include the California courts, which adopted a rule that limited the nexus and proportionality tests of conditions imposed administratively, exempting legislative demands from the constitutional doctrine. Now, that loophole is critical because in Dorado County, they would impose its permits fees legislatively as part of a county-wide land use overhaul adopted in 2004. Now, Supreme Court precedent recognizes that while local governments can charge fees to mitigate for actual public impacts caused by private projects, demanding property in an amount that goes above and beyond the mitigation standard is indeed a taking under the Fifth Amendment. And this is true whether imposed by a bureaucrat or a lawmaker, but until George Sheetz brought his case, the Supreme Court had yet to actually say so. And so, going to the opinion of the court in Sheetz versus County of El Dorado, they would decide that the Supreme Court, and this was a unanimous ruling, was that there was no legislative exception to the Takings Clause. And in previous cases, such as Nolan and Dolan, the court would rule the state and local governments sometimes violate the Takings Clause when they impose exactions as a condition of allowing property owners to develop their land. Now, some state courts, including the California Court of Appeals in this particular case, have held that there is no Takings Clause liability for land use exaction in cases where the requirement was imposed by legislation instead of by a regulatory agency. But in this instance, a landowner had been barred by El Dorado County from building a new home on his property unless he first paid $23,420 of a traffic impact mitigation fee. Now, when we heard the oral arguments in this case, they would reveal that, in the words of both Justice Neil Gorsuch and Justice Elena Kagan, that the court's justices were in fact in what they called radical agreement in rejecting the idea that there was any such legislative exception.
I think you're right about all of that, whether this is a tax is a really interesting question. Whether it's a user fee is a really interesting question. But as I read the Court of Appeals below, they said we're not even going to get into any of that because Nolan and Dolan simply doesn't apply to legislative enactments of any kind, whether it's a tax, whether it's a fee, whether it's something else. And I thought we had taken the case to address that question. And as the Chief Justice has pointed out, I think there's radical agreement on that question today.
Justice Kagan?
Ms. McGrath, I want to follow up on Justice Gorsuch's idea of
radical agreement. And I want to give you suggest what it is that there is radical agreement on and what it is that there's not radical agreement on. And
Indeed, even counsel for the county seemed to abandon the argument that any such exemption exists. Thus, today's unanimous decision to that effect comes as little surprise. And Justice Amy Coney Barrett's opinion for the court would effectively summarize the reasons why this idea that there is a legislative exemption makes little sense. So she says, nothing in constitutional text, history, or precedent supports exempting legislatures from ordinary takings rules. The Constitution's text does not limit the takings clause to a particular branch of government, and the clause itself, which speaks in the passive voice, focuses on and prohibits a certain act, which is the taking of private property without just compensation, according to the precedent set in Knight v. Metropolitan Government of Nashville and Davidson County. It does not single out legislative acts for special treatment, nor does the 14th Amendment, which incorporates the takings clause as against the states. On the contrary, Justice Barrett says, the amendment constrains the power of each state as an undivided whole. And Section 1 thus says that there is no textual justification for saying that the existence or the scope of a state's power to expropriate private property without just compensation varies according to the branch of government affecting the expropriation. And that is according to Stop the Beach Renourishment Incorporated versus the Florida Department of Environmental Protection. And just as the Takings Clause protects private property without any distinction between different types, according to Horn v. Department of Agriculture, it constrains the government without any distinction between legislation and other official acts. Now, at oral argument, it seemed like the justices might actually be interested in going beyond the legislative exemption issue, possibly addressing the underlying question of whether the fee imposed in this case was a taking or not. However, the court chose not to deal with this question, which will now be remanded back to the California State Courts for their consideration. And in a concurring opinion that was joined by Justice Ketanji Brown Jackson, Justice Sotomayor would emphasize that the court did not resolve the issue of whether the fee imposed on Sheetz would be a taking if imposed outside the permitting process. And she argues that the takings liability only applies if the answer to that question is yes. Now, personally, I actually do not think she is correct there. Tying the fee to a land use development permit implicates private property rights in a way that imposing a fee unrelated to development might not. And during oral arguments, Elena Kagan would also highlight the place where the court was in disagreement regarding the facts of this case.
And see if you agree with me. So what there is radical agreement on is that you don't get a pass from unconstitutional conditions analysis just because you've passed generally applicable legislation. And that's, of course, true in unconstitutional conditions analysis generally, and so, too, it's true of unconstitutional conditions analysis in the property area. If there has been a taking, and that taking is being leveraged in the permitting process by generally applicable legislation, there's no pass just because that's the mechanism that's being used. So first let me ask you if you agree with that.
I agree.
Okay. Here are two things it seems to me that the parties fundamentally disagree on, which is probably one of these two things is going to answer this dispute in the end. But there are two things is, number one, is there a taking at all? Because if this is just something like a tax, unconstitutional conditions analysis never comes into play. And you say it never comes into play, and Mr. Beard says it absolutely comes into play. So that's one question that you're very much at odds on. Is that correct?
That's correct.
The second question that you're very much at odds on is, even if you assume that there has been some kind of taking here and that unconstitutional analysis does come into play, and by that I mean what we have in past cases called Nolan-Dolan analysis, right? Even if you assume that that unconstitutional analysis comes into play, it might look very different from what Nolan-Dolan analysis looks like, just because Nolan and Dolan were focused on individual parcels, individual property owners, and this is a general scheme, and it would be very difficult to apply Nolan and Dolan analysis literally to a general scheme, so that there might be ways in which Nolan-Dolan analysis becomes something that, really looks different in application. And I think Mr. Beard says, no, not really, and you say, yes, really. Is that correct?
That's also correct.
So,
And while hints of disagreement are never directly debated in the opinion of the court, we got some sense as to their presence in the concurrence that was written by Justice Brett Kavanaugh, which would be joined by both Justices Kagan and Justice Jackson. So Kavanaugh notes that the court had not previously decided, and today explicitly declines to decide, whether a permit condition imposed on a class of properties must be tailored with the same degree of specificity as a permit condition that targets a particular development. And he further emphasizes that today's decision does not address or prohibit the common government practice of imposing permit conditions such as an impact fee on new developments through reasonable formulas or schedules that assess the impact of the classes of development rather than the impact of the specific parcels of property. And finally, Justice Neil Gorsuch had a concurring opinion arguing, and arguing correctly in my view, that the Takings Clause standards should not vary based on whether the challenge regulation applies to a narrow class of properties or to a broad one. So he said the court notes but does not address a separate question: whether the Nolan and Dolan test operates differently when alleged taking affects a class of properties rather than a particular development, but he asks how could it? To assess whether a government has engaged in a taking by imposing a condition on the developments of land, the Nolan and Dolan test asks whether the condition in question bears an essential nexus to the government's land use interest and has a rough proportionality to a property's impact on that interest. He goes on to say that nothing about that test depends on whether the government imposes the challenge condition on a large class of properties or a single tract or something in between. Once more, how the government acts may vary, but the Constitution's standard for assessing those actions does not. And I think Justice Gorsuch is absolutely right about this point, but as the Kavanaugh concurrence will suggest, there may very well be disagreements about this issue on the court itself. Now, when and if the court takes another regulatory exactions case based on the Takings Clause, there are likely to be divergences between the justices, including some that divide them along the more traditional left-right ideological divide. But it is notable that the court would reach a unanimous and, as again we talked about earlier, radical agreement on the legislative exception issue. And all of this augurs well for those of us who see property rights as one of the most fundamental of all constitutionally protected natural and individual rights. And so in sum, today's decision in Sheetz is far from a definitive resolution of outstanding questions about when regulatory exactions and permit requirements qualify as a taking, but the justices, and by this I mean all of them, did get the legislative exception question right. And let us hope that this is a trend that will continue moving forward. Now, this is really all I have for you guys today, though I just want to say briefly that if you would like me to be able to cover more interesting cases like this one as part of my Supreme Court roundup next term, maybe consider becoming a paid subscriber to Legalese. Because the more people who are willing and able to back the show, the more time I can devote to churning out the kind of high quality and in-depth content about important topics and cases such as this moving forward. Now, you can support the channel on Substack or Locals or Patreon, where you also get exclusive paid subscriber perks or give a one-time donation through PayPal or Venmo. Now, I always hate hitting people up like this because It already does really mean a great deal to me that there are people out there who appreciate the work that I do here. And if you're not able to go that extra mile, don't worry about it. Whether you're a free subscriber or a paid subscriber or just a complete stranger who stumbled onto this video by accident, I still very much appreciate you taking the time to check out my content. So until next time, this has been Bob for Legalese, talking about the Takings Clause, and of course, as always, Carthago delenda est.